Hi, everybody. This is David O'Day with O'Day Schneider PLLC. And today we're talking about Parker v. Levy, a Supreme Court case that asks how far free speech goes for service members, especially in a time of war. In American life, the First Amendment stands as one of the most powerful promises: the right to speak freely, to criticize authority, and express ideas without fear of punishment. But what happens when that right meets the rigid world of the military and discipline? Well, that question came to a head in 1974 in a Supreme Court case called Parker v. Levy, a decision that continues to define what it means to speak freely while serving under a command. Now, Captain Howard Levy was an Army doctor stationed at Fort Jackson, South Carolina during the Vietnam War, one of the most turbulent and divisive periods in American history. Levy was ordered to train Special Forces medics who would be deployed to Vietnam, but he refused. He believed the war was immoral, and he said those medics would participate in atrocities against civilians. Levy also went further. He spoke out to other soldiers, including African American troops, urging them to not cooperate in what he described as an unjust and racist war. The Army charged Levy under true provisions of the Uniform Code of Military Justice, Article 133 for conduct unbecoming an officer, and Article 134 for promoting disloyalty and discontent among the troops. He was convicted by a court-martial and sentenced to 3 years in prison. Levy appealed, arguing that his punishment violated the First Amendment, that he had simply expressed political opinions about a controversial war, something everyday Americans had a right to do. When the case reached the Supreme Court, it forced the justices to grapple with a fundamental question: do members of the military enjoy the same constitutional rights as civilians? And the court's answer was essentially no, not in the same way. In a 5-3 decision written by Justice William Rehnquist, the court upheld Levy's conviction. Rehnquist described the military as a specialized society separate from the civilian society, with its own laws, traditions, and expectations. And that key to the society, he wrote, is discipline, the habit of immediate obedience to lawful orders, and a deep respect for the chain of command. Speech that erodes discipline or encourages disobedience can't be tolerated, even if it would be protected in civilian life. Rehnquist explained that the armed forces must operate with unity and precision, and that liberty in the military context must yield to necessity. In short, Parker v. Levy carved out an exception to the First Amendment, not because soldiers cease to be citizens, but because their role requires a degree of restraint that civilian life does not. The court also rejected Levy's argument that the UCMJ's provisions were too vague. Rehnquist reasons that soldiers, through their training and professional experience, have a unique understanding of what behavior undermines good order and discipline. And what might seem unclear to a civilian court, he said, is well understood within the military environment. Now, this reasoning has lasting consequences. Parker v. Levy became the foundation for all subsequent military speech cases. Whenever a service member is disciplined for making political statements, for criticizing leadership, or posting controversial content online, military courts return to Parker v. Levy to decide how far free speech extends within the ranks. The decision also shaped military culture in a broad way. It affirmed that the armed forces are not simply another branch of the government, that they're institutions built on obedience, trust, and shared sacrifice. And to function effectively, the court said the military cannot operate like a democracy within itself. The Constitution still applies, but its application is filtered through the realities of command. Now, critics of Parker v. Levy have long argued that it gives the military too much power to silence dissent, that it treats soldiers as if they check their citizenship at the barracks gate. Supporters, however, see it as essential to preserving the effectiveness of a fighting force. From their view, the military's purpose is not political debate, it's national defense. And when words threaten to divide a unit or undermine authority, they threaten the mission. Now, over the years, courts have tried to balance these competing values. Later cases like United States versus Wilcox, a Court of Appeals of Armed Forces case in 2008, have refined Parker v. Levy by clarifying that speech can't be punished merely for being offensive or unpopular. It must actually harm good order and discipline. But the foundation laid by Parker remains intact. Speech in uniform is not the same as speech on Main Street. In the end, Parker v. Levy stands as a reminder of a harsh truth that the freedoms that the military exists to protect are paradoxically the very freedoms that may be most limited for those who serve. The case doesn't erase the First Amendment for service members, but it reshapes it around duty, cohesion, and command. And that balance between liberty and loyalty, between the right of the individual and the need of the mission, remains one of the defining tensions of military life. Parker v. Levy made it clear that in the armed forces, free speech must sometimes stand at attention. Thanks for watching the video.